Episode higher juicy news. Mema Ubibia Akwaba. Latest hot. Enkwa Eramede Bremo. Anuti Bomodia say over subscribe to channel. Na while I give video, give us a thumbs up. Na fi share ma wo foforo so na when you be here na wo en semwa ekoso ewo Ghana memo hanum. Afi yembure ye en semwa abeto yepono so. Inti yes I report here about to mama inti.
Suspended Chief Justice is not giving up at all the fight. She's taking the matter beyond the borders of Ghana. And this, we got notice from a social media post from by the Deputy Attorney General, Dr. Justice Shemsai. We're going to put that on the screen right now. He gave some snippets of information. We don't have the full complement of the suit or the application and the reliefs that she's asking for. He says, I can confirm that the Chief Justice, Lady Chief Justice Gertrude Torkonuu, has filed another court case, this time at the ECOWAS Community Court in Abuja, Nigeria, against the Republic. And he goes on to say further that based on the details in this case, which was filed on July 4, her ladyship repeated the same allegations of human rights violations, which are currently pending determination before our Supreme Court and also before our High Court in respect of the ongoing removal process. We know about some of the issues of human rights violations, talked about the location, the fact that her family wasn't allowed in with her, and then also how she was searched and so on. Essentially, her ladyship argues that by her suspension, she has effectively been removed from her official capacity without any final determination, impairing her right to function and serve in a position she was constitutionally appointed to. You have indicated that, you know, at least looking at the review, in as much as, yes, it is not written black and white, maybe some of the things she's raising should be considered. What are those specifically? And then maybe your quick one on this decision that she has taken to seek justice in her view in the ECOWAS court.
Okay, so I mentioned two things specifically. One, that her plea to be allowed to be accompanied by at least one or two relations. I think that one, it's fair. It's fair that she is, because if the Article 146 intended that no other person should be allowed, they would have said so, you see. Okay. But once the Constitution doesn't say that no other person should be allowed in, the fact that they say secret doesn't mean that her relations cannot come. But the same Article 146 says that the person can get other experts to come. So if other experts can come in, the experts come in to help her case, right? That's formally. Yes. These other people who are going to accompany her also come in to help her, emotional support. You see it. Sometimes we underestimate things like that, but ordinary court cases, some people go, their supporters are many. Whilst the person is in, yes, some enter and then there isn't enough space, so some even stand on the verandas, right? But this one, look at it, too. She is at the peril of losing her job as a Chief Justice. Right. The emotional torture that does is beyond imagination. So as for allowing her husband and a daughter, or maybe just make it flexible, two close persons to her, I think it's...
But is that a substantive issue she's looking for?
Yes, she's raised it. You know, because a lot of it's mentally, it's a torture, to be honest. No, it's torturing. She's at the brink of losing that job. So sometimes if you have the husband sitting by her, it gives that emotional support. If the daughter is with her, it gives emotional support. Let's be humane. Ghana will be here, I mean, for a long time to come. It won't be long. There will be another person facing the same thing. And then, you see, just like, look, it wasn't long ago when Chachu went to this Supreme Court saying that submission of no case, the judge didn't give reasons, etc. Oh, he was thrown out. He said, oh, it's desirable. They should have given reasons, okay? But it wasn't done. The trial judge didn't. But he said nothing happened. You see, 2000, that case is in the 2003-2004 Supreme Court of Ghana law reports. We are in what? 2025. The same argument has come up. Now, Torkonuu is at the receiving end, saying that she has not been given the submission, the prima facie ruling. Torkonuu is saying that she's not been given the prima facie ruling. The same thing. The same thing. Just 20 years on. So let's learn. As for me, I've said it unequivocally that the substance, we are not going to, we've all read the leaked petitions. Those are very serious matters. Very serious. So that one, it should go on. But things like give her a copy of the prima facie ruling, let her relation to, we are not saying a whole bunch of them, 10, 20, 30, no. Those are things that we should grant as a minimum.
She even said her bags were searched and...
Oh, that one for security reasons. Maybe if it's a male searching the bag, they should then let a female do. Because it's secret, I should think that they want to see maybe if is there a recording device. Exactly. So if it's a male, I'm just saying if. But as for the search, I think to ensure the constitutional sanctity that the proceedings should be secret, right? Maybe to make sure that people don't go in there with recording devices. Emmanuel, you agree? Just to avoid the situation where somebody, but you know, even if somebody wants to record, even spectacles or even button, you can have your button on your shirt and it's a recording device. Indeed. But that notwithstanding, searching is basic because if you don't search,
good scanners,
that's why they use the scanners, detectors.
Yes.
Okay. Now let's come to her case in the ECOWAS court. That one, you see, let's give some education, please. Under the jurisprudence of the ECOWAS court, the fact that she has 1,000 cases in Ghana, it doesn't stop her from going to the ECOWAS court. Okay? So let's get that very clear. Then
the point that Kweku Annan is going to be joining us on Zoom briefly. There was a point he made about the ECOWAS court recognizing the internal structure, as it were. They would also look at whether she has exhausted all the internal avenues for remedy.
So is the African Court on Human Rights
before anything else? Is that in tandem with the dictates of the statutes of the ECOWAS court?
No, not the ECOWAS court. The ECOWAS court is very clear. I've read at least 2 decisions where they've said a case before a domestic court is not a bar. The ECOWAS court has been very clear. This one is beyond argument. Maybe we are mixing it. What the ECOWAS statute says is that if you have a case before another international court, so let's say you have a case before the ECOWAS court, then you run to the African court. They say international. We can read them if there's time. If there's time.
We'll pull it.
But
yes.
As for the domestic one, so for the lawyers who are interested, if you Google it, you see this case. The registered trustees of Header Resource Center, okay, Human and Environmental Development Agenda versus the Republic of Nigeria. Let me repeat it because lawyers, we are all giving education. It says, the registered trustees of Header Resource Center, Human and Environmental Development Agenda versus the Republic of Nigeria. If you want, suit number ECW/CCJ/APP/40/21. Okay, and the judgment 2024. Or if you want, just Google simply. It's a case pending before a domestic court, a bar to the institution of another case in the ECOWAS court. You will see, you'll find it now. As you keep digging, you'll get the judgments. So that one, there is no argument at all. You don't even need to show that the domestic court will be unfair, they will be biased, political, that it is illusory. No, they just say it is not a bar. But maybe out of abundance of caution, you want to show why the domestic court is not one. If you like, I can read this last line, but that's extremely clear, okay, that it is not a bar. Let's not go and say something that, so listen here. It says, so the case I just read, okay, let's read. It says that the court held in registered trustees of the Socio-Economic Rights and Accountability Project, SERAP, versus the Federal Republic of Nigeria and one other. That's 2016 CCJ ELR at page 433. That where a case is lodged before the local judge under the domestic court system of a member state, there is no bar on the community court entertaining the same case.
You are absolutely right. You know, you can look at that.
Even the
section clearly tells that's consistent with what Lawyer Matikpebo read. Now, our quick search shows that what you're saying is correct.
Yes.
That no, the fact that a case is happening at the local level is generally not a bar to go into the ECOWAS Court of Justice. That is what our search, how you just put it. In fact, I encourage our listeners to also do so. You get it. Yes. But this is why I bring in. Let's understand the basis for Kweku Annan's position, right? So then, if you have to bring in your point as well, Mr. Kweku Annan is a former director of the Ghana School of Law. He's joining us on Zoom right now. But you've been listening. You hear Lawyer Matikpebo's position about the position that you held sometime last week when I spoke to you off record. You had indicated that the ECOWAS Court will take into consideration whether or not the applicant before them has exhausted all internal avenues of redress. Correct?
Well, she exhausting internal remedies simply means ensuring that the proceedings have terminated to completion. They have, gone through every step. You see, she is preventing the steps from being implemented. So she hasn't exhausted. She cannot be said or cannot be argued that she has thereby exhausted, the internal remedies. No. So merely, inundating the court with, incessant applications is no meaningful reason to suggest that she has, exhausted the internal remedies. She has been filing application upon application, and if you look at the nature of the application that have so far being usually considered by the High Court and the Supreme Court, you see that they were wholly, factually, and legally unmeritorious. And if an application is without any merit, the obvious outcome is a dismissal. It will be refused, and they have been refused. And when she launched the first one, you recall that on one of your shows, I indicated that she can file millions of applications, but insofar as Article 146 is concerned, the provisions stand guard over any such application. So we may file repeated applications. They can only create ugly noises in the courtroom, but applications ultimately become a social nuisance. Legally, they are incompetent. And for a Chief Justice, bringing application upon application and being told to their face that the applications lack merit is not good for her own image. It is not good, for the general public. It is not good for Ghana as a nation. That our Chief Justice will file an application that a committee, will assess, evaluate, and see.
But then how do you see this case playing out from where you said? What outcome do you expect of this case, taking into consideration all you have just said at the ECOWAS Court?
One of those, cases, I think, that be a return match. They will ask her, they'll bounce her to come back to Ghana. I don't see how the ECOWAS Court can change our rules of procedure. Our rules of procedure are, firmly embedded in the High Court rules with the support of, the Evidence Act of 1975 and RCD 323. They are there. It is a procedure for, Ghana. It is not the procedure for ECOWAS. It's for Ghana. And ECOWAS doesn't have, a West African sub-regional procedure that we are applying and violating. It is our own rules of procedure and evidence that we are applying, and therefore, taking the matter out of the purview of our court to the ECOWAS court is not going to achieve the desired, purpose. I think it will be defeated, and at the end of the day, I think that upon a sober reflection, the Chief Justice will realize that she has shot herself wrongly in the foot. No one else. She's making her bed and she's lying in it. And it saddens and pains me that she's adding more insults to injury. I've said elsewhere that.
Right. And that point that you made, and that's where Mr. Kwaku are bringing. So, people, that's some detail to the position that he took. That ECOWAS court cannot necessarily change the rules of engagement, essentially, if you look at it. But then again, he still holds the view that there are a number of applications regarding this matter, and you see the Deputy Attorney General reference it as well, that some of the issues he's seeking as reliefs in this application are also being tried already here. Yes. So why not wait for the outcome before going?
Yes, so as we said, the ECOWAS court is saying they can also look at it. And don't forget that, you see, in law, as we, in human nature, we are different. Some people are conservatives, others are liberal, some are in between, etc. We should bring the psychologists. I keep saying that that's one area we don't pay attention to. Sometimes we just see human beings and we think everybody is good or everybody is bad. No, but there are differences. So in the same way, in law, there are various philosophies. So you hear the textualist approach, the purposive approach to interpreting statutes, constitutions, etc. Right? Yeah, so to that extent, a case that you may see as bad here, it's possible in the other forum, they may see it as good. You say, so I don't want to say anything about the substance of her case. No, as I've said, she's struggling already, right? I mean, the torture, okay? The torture is a lot, and you see that's how come I've repeated here several times that if I had my way, I would have seen if we could have mediators come in and see how she can be allowed to exit with a resignation. Because now you see where we've been taken to ECOWAS court. So those things have been published with the ECOWAS court. Who knows, from ECOWAS court, maybe she'll go to the African court. We don't know where else. So by the time we are done, all of us would have been fully dragged in. So sometimes, I mean, if you give the person an exit, for me, what is clear is that once it's an exit to go, fine. Okay. But not an exit that come back, no. Right. No, that one I'm very, very clear that no. These are very serious matters. Either we go into the details and get merits, or she should be given an opportunity to leave, but not the one that come back and occupy the position without us going into the case. As for that one, if she wants to come back into office, then let's go into the case. Okay. Okay, because those are very serious matters. We can't sweep those under the carpet. Otherwise, our democracy will not grow. So that let's be very clear. Indeed. So let's see how we can do, because now it's becoming just one too many. Today we are in this court. The next day we are in another court, and the publications, it's dragging us. It's dragging us. I don't think that it helps us. Yes, somebody say, well, maybe it's generally a taboo conversation. Perhaps if we don't get a political settlement to it, and she continues, by the time we are done, okay, we will now in future discuss these matters without feeling squeamish about them, right? They will no longer be taboos. They will no longer be a Pandora's box. Okay, that's also another thing. But if we can resolve this quickly, that would be better so that we get closure.
Thank you very much.
An Accra High Court to dismiss a case filed by the suspended Chief Justice Gertrude Torkonuu. Now, documents filed in court by the Deputy Attorney General, Dr. Justice Shemsai, argues that the matters raised by the Chief Justice have been dealt with or remain pending at the Supreme Court. The Chief Justice has, in the last few weeks, urged the Supreme Court and now the High Court to halt her removal process. Now, this action by the Chief Justice is a sixth legal action filed in court since the presidency announced the receipt of petitions against the Chief Justice. My colleague Joseph Akablain is joining me in the studio. It's a legal affairs correspondent to get details of exactly what the Deputy Attorney General filed in court today. What do we know, Joseph?
So we know that the Chief Justice filed this action after her initial push at the Supreme Court did not succeed. You recall that was the very first time the Chief Justice had herself taken a matter over to the Supreme Court. She filed an affidavit in which she made series of allegations. And when it went over to the Supreme Court took the view that those affidavits disclosed matters that fell within the proceedings that took place at the committee. And so the court struck out those affidavits. Her request for the proceedings to be put on hold was also not upheld by the court. Now, and after all of that, she now filed a process at the High Court. In fact, the very first time we heard of this process that has been filed at the High Court was disclosed by the Chief Justice herself. In that press conference that she addressed, she did indicate that she had instructed her lawyers to file a judicial review action challenging some of the matters that have taken place at the committee hearing. In effect, what she's seeking is for those proceedings to be put on hold. Key amongst the concerns has to do with the fact that she says up until now she has not received a ruling or a determination, the prima facie determination. She's yet to receive it, so she does not know which aspects of the petitions filed against her have crossed the prima facie threshold and which of the allegations have not. And so she's basically showed up at the committee, and all she's responding to are the matters that were given to her, for which she provided response to at the initial level, even before the committee was set up. So she doesn't even know whether her copies that she has is the same thing that the Chief Justice the committee also has in its possession. And those are all matters that she has put in the document that she has taken over to the High Court. Now, the Deputy Attorney General has responded on behalf of the Republican. Right. Makes the point strongly that those matters that are being raised by the Chief Justice are matters that have been dealt with by the Supreme Court or they remain pending at the Supreme Court. In fact, they list the 5 other cases that have been filed at the Supreme Court so far. I'm going to run you through the case titles so far. So the first one is the case that was filed by the Chief Justice herself, not the first in time, but in terms of the list as put out in the court documents by the Attorney General, Her Ladyship Justice Gertrude Araba Esaba Torkonuu versus the Attorney General and 5 others. The suit number is provided there. Then Center for Citizenship, Constitutional Electoral Systems, LBG versus Attorney General and 2 others. Then there is Vincent Ekoasefua versus Attorney General, Ebenezer Osei Owusu versus Attorney General, and Theodore Kofi Atta Korte versus Attorney General. So those are the 5 cases that the AG makes reference to make the point that these are cases in which the same matters have been urged on the court. And the court has either dealt with it or the matter remains pending at the Supreme Court. And so you cannot come back to the High Court or come down to the High Court, the lower court, and ask the High Court to pronounce on those same matters, especially when they've either been dealt with or they remain pending. And so they are basically asking the High Court to strike out the judicial review action that has been filed by the Chief Justice.
And essentially, what then this? How is it going to impact on the proceedings, especially at the Supreme Court? Because you indicate that the Deputy Attorney General, in filing today, indicates that there are some of the issues that are pending at the Supreme Court already. Does this development have any consequence whatsoever on the process at the Supreme Court as filed already?
In fact, what we do not know is whether the request that was made to the High Court by the Chief Justice, whether it includes an application for injunction or not. We also know that the Supreme Court, in that recent decision, dealt with the issues of whether an application ought to stop a constitutional body from performing its function. We know that in one of the concurring opinion, Justice Emmanuel Yonikulendi makes the point quite strongly that as far as he's concerned, he thinks that the distinction needs to be made when it comes to constitutional functions. Such an application should not stop the committee from hearing it. What we can say for a fact is that This particular application has been filed by the Attorney General. It's slated for hearing on Tuesday, the 15th of July, 2025. The request to the High Court to strike out the application that has been filed by the Chief Justice. So we'd have to look up onto that day to know what will transpire in court in terms of the concerns that may be raised by the Attorney General or lawyers for the Chief Justice.
Now, stay with me, Joseph. Let's bring in Lawrence Bwampong, who is a private legal practitioner as well. Counsel, good evening. Thank you for joining us.
Good evening, Mr. Counsel.
Now,
thanks for the pleasure.
Perfect. Now, you heard my colleague and also a senior legal affairs correspondent, Joseph Akabale, lay the basis for the Chief Justice's now this application at the High Court. The Deputy Attorney General is making the point that the matters raised by the CJ, the suspended Chief Justice, have already been dealt with or remain pending at the Supreme Court. I mean, does this position have any merit as against what the CJ is asking for right now?
Yes, Mr. Counsel. Thank you for the opportunity once again. And let me say good evening to your cherished listeners. Yes, I've looked at the affidavit in support of the application that has been filed by the Deputy AG. And he makes the case that the matters pending before the Supreme Court has a bearing on the application for judicial review by her ladyship, the Chief Justice. Yes, because the matter is pending, I wouldn't want to go into the merit, but let me just say that the matter before the High Court is for judicial review. And when we talk about judicial review, simply put, it means that when you look at our Constitution, Article 141, the High Court has what we call supervisory jurisdiction over all lower courts and lower adjudicating bodies. So the committee for this matter involving her ladyship is exercising a judicial function, quasi-judicial. Therefore, the High Court has that supervisory jurisdiction over that committee. And I have not seen the application which has been filed by the suspended Chief Justice. However, my understanding is that she is before the High Court because it is the proper forum when you want to go for any relief in the nature of judicial review. That is for sexual right. If you want to quash the process or the proceedings before the committee. We all heard her speak to the nation and she complained about certain acts, such as, a breach of her natural justice, fair hearing and all that, human rights matters. So it is a proper forum. As to whether the issues in her affidavit in support for a relief in judicial review has a bearing with the matters before the Supreme Court, it's for the High Court to determine. Though, let me be quick to state that we all know, and this is known by everybody who has been following these matters, that some of the things that she complained about in the Supreme Court, in her own case, the one that she was the applicant, she made mention of some of these issues. It is also a fact that some of the things that she said in her supplementary affidavit were struck out by the Supreme Court. So those are not matters which are still pending before the Supreme Court, because that matter has been dealt with. There's a ruling on it. So that is what I can say.
She's always contended, and this was even at the press conference last week, that she doesn't have a copy of the prima facie against her, and she doesn't even know whether the copies of the petitions that she has is the same that the committee that she has appeared before them really has, and being employed in the process of the hearing against her. Now, is it a legitimate suspicion to have that the details of the petition she has will be different from what the committee is having? Does it have any basis whatsoever?
Yes, Mr. Kennedy. Sometimes it's difficult to answer some of these questions because, the committee has no spokesperson to, respond to this matter. However, what we all do know is that the Chief Justice herself admits that she wrote a letter to His Excellency the President requesting for copies of the petitions against her. So I find it difficult to understand if she's complaining that she doesn't have those petitions. It's quite difficult for me to understand that. Further, during her press conference, she told the whole nation the content of the petition. So she has always had the petitions. So for me, respectfully, I do not believe that the petition is the issue. All three petitions, she told us the content, which suggests that she has in her custody copies of the petition. So it is difficult for me to see that as an issue. I understand her complaining that when she appeared before the committee, they have not given her copies. But we don't know she already has copies. So that for me is a bit difficult for me to comprehend.
But how do you see things playing out? I mean, the Deputy Attorney General filed on behalf of the state asking that the High Court strikes out this particular case. Is it one that you see playing out this way, or as it were, the court will now have to determine whether the details or the reliefs that she's seeking in this supplementary affidavit has any impact on what she's seeking at the Supreme Court, essentially?
Okay, so this is how I see the High Court going about it. You know, she has brought an application in the nature of judicial review, and that application will be supported by an affidavit. In the affidavit, she would depose to the things that, in her view, okay, she sees as breaches whether of natural justice or whatever. Then the court is going to have the opportunity to also listen to the Attorney General. Don't forget, what the AG has filed now is not in response to her application. It is another application to set aside, you get it, to strike out her application for judicial review. So the Attorney General will have an affidavit in opposition to counter the argument that has been canvassed by her leadership. And the court will be called upon to weigh the two, to look at her depositions and marry that with that of the AG. Where there are merit in it, that will form the basis of granting the application or refusing it. I hope you get it.
I get the point. I think it's pretty, yes.
This is a separate motion which has been filed by the AG, okay? And he's also saying that he wants to strike out what has already been filed by the CJ based on certain reasons which he has deposed to them in the affidavit. So the court is going to look at it. So the two applications will come on that day. And by practice, because this current one, that the motion we are discussing, the motion on notice for an order to strike out the application for judicial review was recently filed, that will be taken before the application for judicial review.
It's going to be a day to watch. I mean, this case is expected to be heard on the 15th of this month. So I'm sure how the coming days will look like. We'll certainly connect with you again, Counsel. And I do appreciate your thoughts and analysis on this particular issue. Thank you so much.
Thanks for watching. Give us a thumbs up. Subscribe for more videos. And don't forget to share the video to all platforms. I'll see you in my next video.
Thanks for watching. Like and share the video. You can also drop your comment. Please don't forget to subscribe. Click on the bell to turn on the notification. Thanks for watching. Like and share the video. You can also drop your comment. Please don't forget to subscribe. Click on the bell to turn on the notification.